Two people buy the same will, same site, same state, same price. One plan works. The other sends the money to the wrong person. The difference is not the service they used. It is one form neither of them thought about. Without a will, state law decides who receives your probate property, and a judge who has never met your children decides who raises them. So the real question is not which service is best. It is which of two categories you are in. One of them you can finish before you go to bed tonight. The other one will cost you if you try. Start with the simple test. You know who should receive your property. You know who should serve as executor. You know who you would nominate as guardian. There is no blended family, no special needs planning, no property in another state, no business, no assets overseas, and no relative who would fight it. That is a straightforward estate. And for a straightforward estate, an online will is not the budget option. It is the correct one. The first link in the description opens LegalZoom's will plans. The tier they show you first is not the one most people should be buying. Basic will is $129 for one person and $229 for a couple. That covers the will itself, pet provisions, document storage, 30 days of revisions, and one printed set mailed to your door. $20 more moves you to Pro at $149, and it is the same $20 gap for couples. From $229 to $249, that $20 adds 4 documents: a healthcare directive, a medical power of attorney, a financial power of attorney, and a HIPAA authorization. Read that list again because it is the whole point. Those 4 documents work while you are alive. The will does nothing until you are gone. Buy the basic tier and you have solved the easier half of the problem, and nobody finds out which half until someone is standing in a hospital hallway with no authority to make a decision. One thing to know before you click. The attorney consultations attached to Pro renew at $25 a month after the first 30 days. Premium renews at $199 a year. Neither is hidden, neither is loud either. That is the case for clicking. Here is the case for not clicking, and it is shorter than you think. A questionnaire cannot ask a follow-up question. It cannot notice that the answer you just gave contradicts a document you signed in 2011. Children from a previous relationship. A beneficiary receiving needs-based assistance. Real estate in another state. A stake in a business. A plan to disinherit someone. Property overseas. A relative who has already made it clear they will contest it. Any one of those and what you are paying a lawyer for is not the drafting. It is catching the collision between family rights, ownership rules, beneficiary designations, trusts, and state law before it becomes a court date. LegalZoom says the same thing on its own site. Blended families and special needs beneficiaries are situations where it points you toward an attorney. If you recognized yourself in that list but not enough to book a consult, the second link puts the question in front of an estate-focused attorney tonight. Ask it plainly. Given my family structure, my assets, and what I want to happen, is an online will enough, or does this need a custom plan? 2 things before you use it. Ask for someone who handles estate law specifically, not general legal. And read the payment screen slowly because the join fee and the monthly membership are 2 separate charges. Treat the answer you get as a screening step, not representation. Now the part that applies to both categories and the reason those 2 identical wills ended differently. A will generally does not control retirement accounts, life insurance, payable-on-death accounts, or property held with survivorship rights. Those pass by the beneficiary form or the ownership arrangement. They do not check what your will says first. Go back to the 2 people who opened this video. One of them remarried a few years back and updated the will that same year. Never touched the beneficiary line on a policy opened long before the second marriage. The will names the current spouse. The policy still names the first one. The policy wins. A will signed incorrectly and a beneficiary form left unupdated fail the exact same way, quietly, and only once it is too late to fix. 3 things people ask before they buy, so here they are before you spend anything. Is it valid where you live? The documents are state-specific and drafted by attorneys. What that does not mean is that a lawyer reads your particular answers. That only happens on the tiers that include attorney access. Does buying it make it real? No. It becomes real when it is signed and witnessed the way your state requires, and that step is where do-it-yourself wills actually fail, not the drafting, the signing. How long does it take? The questionnaire runs about 15 minutes. Documents are typically ready to download in 2 to 3 business days. Then you print, sign, and witness. Anyone promising a finished will in 20 minutes is selling you the questionnaire, not the plan. This is general information, not legal advice. One more thing worth knowing tonight. A will is not a document you finish. Marriage, divorce, a new child, a move, and a change in what you own each hit it differently, and some of them quietly rewrite who inherits without anyone touching the paper. Next video walks all five, so subscribe if you would rather find that out now than have your family find it out later. Simple estate, clear wishes. First link, one evening. Not sure which category you are in. Second link, one conversation. Then do the part nobody schedules. Pull up every beneficiary form you own and read the name on it out loud. The decisions are already made. All that is left is writing them down somewhere they count, because owning a will is not the goal. The goal is a plan that still works on the worst day your family will ever have.